purpose calendar for the State Court of Fulton County. Today, which is February 24th, 2022, almost the end of February, would you believe it or not. But these are a list of misdemeanor cases in which individuals have already been formally accused by the prosecutor, which is the Solicitor General's office, and bonds have already been issued in their particular cases. We are going to be addressing mostly cases from folks who are still at Fulton County Jail. And I'm sorry. I'm still going to continue. And these cases are either going to have a particular plea offer on the table, and we would have a plea hearing if the defendant wants to proceed. Otherwise, we will arraign the case. In other words, the defendant will enter a plea of not guilty, and the matter will be scheduled for a trial in the future. If you are a defendant currently with an accused case or cases, please remember that this is an open, active, recorded proceeding. This is virtual open court. Any statements that you make during the course of this proceeding, your statements can and will be used against you in the treatment of your case. So if you have counsel, please let your attorney speak for you, especially regarding the facts of the case. If you have a right to an attorney, if you cannot afford one, we have counsel from the Public Defender's Office and Conflict Office to represent you. Let's see now, Courtroom 2, who do we have to begin with?
Your Honor, we have position number 3, Mr. Willie Dura.
Okay, we have, repeat that name again. Is that 4? I have Willie Ray Dura for positions 4.
Oh yeah, I'm sorry. Yeah, you're right. You're right, Your Honor. I'm sorry.
No, that's quite all right. Just wanted to be sure I'm addressing the right person.
Yeah.
Okay, this is Willie Ray Dura in Courtroom 2. Case number 22 CR 0006898. Mr. Dura, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finling. And Mr. Finling, we have Mr. Dura as well for our 11 o'clock calendar. Is that correct?
So it was a mix-up. There's a Dura and a Murrah that's on the competency. So it's almost one letter off. So no, it's not.
So it's not the same person.
Not the same. Yeah, I sent a correction thereafter. So it's a different person.
All right. Just want to be sure. Thank you.
Yes, Judge.
So Mr. Dura, and what's the announcement for Mr. Dura with the D?
Yes, Your Honor. Mr. Dura is going to be a non-negotiated plea judge with jail time at issue.
All right. Mr. Dura, we are going to have a hearing in which the state is going to make a recommendation as to what their proposed sentence is if you decide to plead guilty or no contest to the 1 count of simple battery from November 21st, 2020. Mr. Finling, your attorney, will then give me an alternative recommendation. I will let you know which recommendation I will accept before you make the decision as to whether you want to proceed with the plea. Do you understand, sir? All right. Miss Webb, is it?
Yes, Your Honor. Good morning.
Good morning. Ms. Webb, yes, please. Sorry.
Yes, Your Honor. The state is recommending 12 months to serve, 30 days, credit for time served, 14 days, balance probated, a stay away from the incident locations at 3727 Clovis, that's CLOVIS Court, Northwest, Atlanta, Georgia, 30331, and 415 Hillside Drive, Atlanta, Georgia, 30310, which is the victim's home. No further contact with Ms. Shakita Walker. That's Shakita, SHAKITA, Walker, common spelling, Family Violence Intervention Program, and 60 hours of community service.
And what is the basis of the state's case?
Yes, Your Honor. In this particular incident, Mr. Dura attacked Ms. Shakita Walker by punching her in the face and jumping on top of her. She informed the officer that she was afraid of him. And Your Honor, we are majorly making this recommendation based on the defendant's criminal history. There is a 1988 case that is an armed robbery with a non-disclosed conviction that I do not want to put on open court. And he also has an open ag assault case from 2018.
Is that involving the same victim?
No, Your Honor.
All right. Mr. Finley?
Yes, Judge. We are asking for this to be a time served deal. As Ms. ASG pointed out, they are asking for to serve 30 days, credit for time served 14 days. So that would mean Mr. Dura would need to serve one more day. He has already served 14, so I'm not quite sure what that one extra day would accomplish. We are also asking for the 60 hours of community service to be reduced. Mr. Dura is approaching his 53rd birthday. He needs to get back on his feet. He's lost out on a lot of the money he did have before his incarceration. So we are asking for the time served and a reduction of that community service. And one more thing, Your Honor, as pointed out, that conviction from 1988, that is pretty remote. That is about 33 years ago. So I would like the court to take that into consideration. Thank you, Judge.
I'm just going by this.
I'll accept the recommendation of 12 months to serve 30 days, credit for time served. I'll say 12 months to serve 28 days, credit for time served, 24. Let me repeat that. Okay. 12 months to serve 28 days, credit for time served 14 days. If he has no other holds at the jail, he should be released and placed on probation. While he's on probation, he will need to complete 60 hours of voluntary community service, complete the 6-month domestic violence intervention program, and stay away from Ms. Shakita Walker, no contact with her, stay away from the Clovis Court and Hill Street location, and no drugs, no alcohol, no weapons, and no firearms. This is the recommendation. So he will be placed on probation immediately after he's been released, and I will waive all probation fees for him to pay and complete the 6-month domestic violence intervention program. He must enroll in that program within 60 days of being released. Mr. Dura, that is the recommendation that I will accept. If your other open case is not holding you at the jail, you should be released within 24 hours to begin probation. Is that something that you'd like to accept?
No, ma'am.
Okay. So in that case, there is no plea. He will be entering a plea of not guilty. Is that correct, Mr. Finley?
Mr. Dura, when we discussed yesterday, you did want to, I told you I was going to ask for the time served. You said you wanted to plead guilty. Are you changing your mind on that?
No, sir. I didn't understand what you were saying.
Oh, Mr. Dura, would you like me to explain it again?
Yes. I also want to understand.
The recommendation that I will accept is 12 months to serve 28 days, credit for time served 14 days. Since the sheriff of Fulton County normally gives you a 2-for-1, you would have completed your time at the jail, and you will be released within 24 hours. If your other open case is not holding you at the jail, you should be released within 24 hours. Upon being released, you will report to probation no later than Monday, at which time you will begin your probation. While you're on probation, you need to stay away from Ms. Shakita Walker. You cannot return to Clovis Court or the Hill Street locations. Within 60 days, within 2 months of being released, you must begin your domestic violence intervention classes at your expense and complete 60 hours of voluntary community service. You have 11 months to complete all that, but you must enroll in the domestic classes within 2 months of being released. You will pay for those classes, but you will not have to pay for probation fees. You will report to probation every month.
Okay.
Is that something that you would like to consider?
No, no, ma'am.
All right. Mr. Finley,
If I-
let me ask the question correctly again. Mr. Dura, are these the terms of the sentence that you'd like to accept?
Yes. Yes, ma'am.
Okay. So you are willing to go on probation not pay probation fees, but complete the classes and the community service. Is that correct?
Yes,
And you will stay away from Clovis Court and Hill Street and have no contact with Miss Chiquita Walker. Is that correct?
yes, ma'am.
All right, Mr. Findling, I'm satisfied that he wants to proceed with the plea. Are you?
I am, Your Honor. He was adamant yesterday that he wanted to plead guilty, and if nothing's changed, then yes, I would feel comfortable, Judge.
All right. Mr. Dura, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes? No?
Yes,
All right, put your hand down, please. Mr. Findling, does the defense stipulate to venue and ID?
Yes, Judge.
All right. Mr. Dura, first of all, have you taken any medication or alcoholic beverages that may impair your ability to understand the proceedings?
no, ma'am.
And so far, based on my explanation and your attorney's explanation, have you understood the proceedings so far?
Yes, ma'am.
And if you decide to undertake this plea offer, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel to challenge the state's evidence, present your defenses, challenge the witnesses, as well as confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
No. Yes, yes.
Is anyone forcing you to or inducing you to take this plea today?
No, ma'am.
How do you plead to the one count of simple battery?
Guilt.
I accept your guilty plea. Your sentence is 12 months, to serve 28 days, credit for time served 14 days. You'll be placed on probation. You have to report to probation within 48 hours of being released. Once you are on probation, all probation fees will be waived, but you would need to complete 60 hours of voluntary community service. You will have 11 months to complete that. And you need to complete the domestic violence intervention program. You must enroll in those classes within 60 days of being released. That is 2 months. So in that 2 months, you would need to make sure you have the funding to pay for those classes and complete them. At all times while you're on probation, you will report every month. You are to stay away from 3727 Clovis Court in Atlanta and the, I believe it was a Hill Street location, Ms. Webb?
Yes, Your Honor, that is 415 Hillside Drive, Atlanta.
Oh, Hillside Drive, okay. And at all times also, you have to have no contact with Miss Chiquita Walker. Stay 200 yards away from her. Do not communicate with her in any way, form, or manner, especially through any kind of phone or computer device, or through a third party, and definitely not in person. Any questions, Mr. Dura?
No, ma'am.
All right, make sure you do not consume any illegal drugs and no weapons and no firearms.
Okay.
All right, that concludes this case. We are at 6 South. 6 South, who do we have, please?
This is number 2, Mr. Barrett.
All right. We have LaCoy Barrett. Is that correct?
Yes.
All right, Mr. Barrett, you have a right to remain silent during the course of this proceeding. Any statements you make, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Findling. Mr. Findling, this is going to be a negotiated plea. Is that correct?
That's correct, Judge.
All right. Mr. Barrett, if you please raise your right hand, do you solemnly swear and affirm? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. Barrett, we are going to first hear the plea recommendation from the prosecutor. Then I'm going to hear from your attorney before I ask you any questions. Ms. Webb?
Yes, Your Honor, the state's recommendation is going to be 12 months to serve, 30 days, credit for time served, balance suspended, and a stay away from the incident location at 1046 Dill, that's Dill Avenue Southwest, Atlanta, Georgia, 30310.
All right. And how many days is he being given credit for? Well,
he's been confined for 281 days, according to my records.
On other charges?
Yes, Your Honor, he's being held.
So this is basically a time served and stay away, correct?
Yes, Your Honor.
All right. Mr. Finling, does the defense stipulate to the factual basis, venue, and ID?
Yes, Your Honor. We do stipulate each of those and agree to the state's recommendation, Judge.
Understood. Mr. Barrett, are you under the influence of any kind of medication, drugs, or alcohol?
No.
Have you understood the proceedings so far?
Yes.
And are you satisfied with the representation of your counsel?
Yes.
If you decide to plead guilty to this charge of loitering and prowling, you will have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to confront your accuser, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to this one count of loitering and prowling?
I plead guilty.
Your sentence is time served, and that concludes this case. Once you are released, based on any other holds you have, you are to stay away from 1046 Dill Avenue in Atlanta, Georgia. If you return to that location, you will be arrested again for trespass. Do you understand, sir?
Yes.
All right, thank you and best of luck. All right, courtroom 2, who do we have, please?
Your Honor, we have Antoine Martin.
Antoine Marley, M-A-R.
Martin.
Okay, I got
Yeah.
position 6.
Thank you.
All right, and Mr. Martin's case is 21 CR 008-022J. Mr. Martin is going to be a negotiated plea. Mr. Martin, you've been advised of your rights, and your counsel is Mr. Zach Finley. May I place you under oath, sir?
Right
Do you
hand's good.
Good. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Correct, ma'am.
Thank you. You may place your hand down. Ms. Webb, what's the recommendation for Mr. Martin?
Yes, Your Honor, the state is recommending 12 months to serve 100 days, credit for time served 50 days, balance probated, a stay away from 2936 Larchmont, that's LARCHMONT Court, Northwest Atlanta, a MHET, and no further contact with Ms. Keisha Probst. And it's Keisha, Keisha, Probst, PROPST.
All right. Mr.
It's
Finley?
post and restitution.
Mr.
And
Mr.
I
Martin,
love my grandma.
Mr. Martin, I advise you to.
I'm sorry.
You're okay. Yes, Judge. We do agree to the state's recommendation. We are asking for the probation fees to be waived, as well as after the MHET, if Mr. Martin could be on non-reporting status.
Do we have a definitive address for him?
I do not have a definitive address. He did tell me that he could possibly be with his brother, but I do not have a 100% address, but told him he needs to get that to probation as soon as possible.
What's the name of his brother?
It was it Clark Williams?
Different last name?
Clark Williams, I know Clark Gable.
That's the Mr. Martin. That was the gentleman that was with you yesterday when we were speaking. That was the name he said was Clark Williams. He said
He's talking about my brother twice removed, but same page. Oh, he's talking about Clark Williams the fourth.
that was the name. That was the name. Your friend
No,
was.
that's my pal. That's my friend. He's a great man. He's got 9.5. I don't know who does his test, but I think my mother needs his test. I think somebody should tell him that.
All right. Mr. Williams, Mr. Martin, I am not going to accept this plea unless I have a definite address for probation so that you can.
Oh, you have one?
Probation. I don't have a good address on you. I don't have a good address on any family members from which probation can contact you. So.
Okay. I'll give you your address, ma'am. It's 162 Chappelle Road.
Repeat that.
162 Chappelle Road. Like the show, Chappelle Road. Like the show, ma'am.
City.
I'm now Coach Inti. I'm my depth coach, my art team, and obviously my Xanax. So I'm very aware of what's going on now. And I have been saying for a minute, but I may have the most detrimental state and traumatic was just.
All right,
Mr. Martin, let's just make sure, most important thing, let's just make sure we got that address. So that was 162 Chappelle Road, and was that Atlanta?
It's Atlanta, Georgia. It should be Atlanta, Georgia, but I don't know if there's anything between Atlanta, Georgia, and Atlanta, Georgia.
all right. We're going to reset this case to next Thursday. And Mr. Findling, we're going to make sure that we have a.
No, that's a
specific
different address.
address.
That's a different address. Just if you need, you can call
We're going to confirm his address and then we will address a plea. This
Probation, please.
time served plea.
Probation.
And also with regards to an MHET, if he is a recipient of any benefits, we would need to know who is his recipient of or his caretaker. All right?
Understood, Judge.
All right. Thank you.
God bless you, Judge.
And God bless you too. Thank you. Next case, counsel, deputy.
I'm going. Yeah. We'll go back to the phone. Oh, that's fucked up.
All right. Let me see. As soon as courtroom 2 is
And
ready.
Your Honor, just for the record, I have on the police report that he is residentially challenged.
Yes, we know that was noted on Odyssey as well. So as soon as we have some idea of who's the recipient of any benefits, that can be some way of reaching him. And otherwise, putting him on probation is not going to work out. All right. We have, who do we have in the seat, please?
This is position 1, Mr. Allen.
All right. And sir, if you'd like to walk all the way across, not through those double doors, all the way to the end of the room. Yeah. And come forward to this podium right here with a microphone. We have someone in the courtroom for this particular case. We have Mr. Mr. Dennis Allen, case number 22 CR 0000525F. Mr. Allen is accused of obstruction of an officer, misdemeanor possession of marijuana, misdemeanor possession and use of drug-related objects, and carrying a concealed weapon. Good morning, sir. What's your name, please?
My name is Sabu.
Repeat that.
Sabu. S-A-B-U.
S-A,
B-U.
Mr. Sabu. And Mr. Sabu, is that your last name?
No, Divine is my last name.
Repeat that.
Divine.
Spell that.
D-I-V-I-N-E.
D-I, Mr. Sabu Divine.
Yes, ma'am.
And how are you related to Mr. Allen?
Oh, that's my friend.
A friend?
Yes.
Okay, thank you. So we have Mr. Divine in the courtroom on behalf of Mr. Allen. This is position 1. Mr. Kibble, is that your client, sir?
Yes, Your Honor.
All right. Mr.
We're
Allen, go ahead, sir.
I'm sorry. This is going to be a bond hearing today, Your Honor.
All right, thank you. Has the case been arraigned?
I don't believe that it has.
All right. So your client plans to enter a plea of not guilty?
At this time, yes, I would ask if ASG Webb could email to me copies of the accusations and the witness list.
All right.
Yes, Your Honor, that's no problem.
If,
All right.
if you could also send me the police report, I would appreciate that very much.
Yeah, sure, no problem.
Thank you.
So with regards to Mr. Allen, if we could unmute courtroom 2, Mr. Allen, I understand from your attorney, Mr. Kilbo, that you plan to enter a plea of not guilty and have the case scheduled for trial. Mr. Kilbo, do you waive a reading of the accusations?
Yes, Your Honor.
All right. Mr. Allen, you've been advised of your right to remain silent, and your attorney is Mr. Kilbo. The Fulton County Solicitor General's office has formally accused you of the 4 misdemeanor offenses I have just listed, including carrying a concealed weapon, which allegedly occurred in Fulton County, Georgia on February 4th, 2022. Upon your entry of a not guilty plea to these 4 charges, your case will be scheduled for trial before the division judge. You have the option of selecting either a bench trial, which would be a trial before the judge, or a jury trial. In other words, a trial in which citizens would be appointed as jurors to determine the verdict in your case. In either event, at the time of trial, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution succeeds, you could be convicted of one or more of these charges and face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead, Mr. Allen?
Not guilty.
All right, sir. Your case has been arraigned. Mr. Kilgore, at this time, do you have a decision as to what type of trial you would like to have, a bench or jury?
Your Honor, candidly, I think that this is eventually going to be a negotiated plea. For now, I would say a jury trial.
Okay,
Ms. Webb and I are in the process of negotiating.
all right, sounds good.
But as of today, we don't have a resolution, and that's why I've
Understood.
asked for bond hearing.
Understood. He's presently got a $7,000 surety bond that was issued on February 7th, 2022. Looks like there's a $5,000 good bond on the weapons charge. Okay, what is the reasons to modify that bond?
Your Honor, at the time of the initial bond hearing, there was some confusion about whether or not Mr. Allen was in fact a convicted felon. And I have researched that. Attorney Webb and I did not speak about this exactly, but there was some confusion of that because he had been arrested for a felony in Cobb County at one point. However, I was able to look at the Cobb County records and see that although he was arrested originally for a felony, he ended up entering a plea to a misdemeanor in that case. Therefore, that is information that has changed. Initially, there was some question about whether or not this would be transferred, but given that there's now no doubt, at least from my perspective, that he's a convicted felon, he is not a convicted felon. Therefore, it is only a carrying concealed weapon case. He does not have any means to post bond at this time, so we're asking for a signature bond. He has, just this morning, I've noticed that he has a second case that is holding him with a $2,000 bond. That's a battery case from 2021. It was on the state all-purpose, I do not represent him in this case, but it was on the state all-purpose calendar 2 days ago. And he has a $2,000 bond on that case. I don't know where that bond came from because he had been previously released from jail on that case. I don't know how it reappeared, the mechanism. So he has a total of $9,000 bonds, $7,000 in this case. So we're asking for a signature bond. Alternatively, Your Honor, if Your Honor is not willing to grant an unsecured judicial release to Mr. Allen, we'd ask for a $500 bond on each of the counts for a total of a $2,000 surety bond. Mr. Allen was preparing to return to work, doing construction with his uncle. He's been in Atlanta for 10 years. He's not currently on probation. His probation in that Cobb County case had just terminated at the time that he was arrested in this case.
All right, thank you. Pre-trial, do we have Ms. Harrison?
Good morning, Judge.
Harrison, good morning. Do you have a record of any felony convictions?
No, I have a 2017 possession of cocaine and possession, purchase, or sale of marijuana. He was offered first offenders, but it's not indicated if it was sealed or not.
I completed it. I'm sorry. I did complete it.
That's, Your Honor, that was I believe that's the Cobb County case. He ended up pleading guilty, I believe, to drug-related objects and possession of marijuana. So he pled to the misdemeanors, the charges were reduced to misdemeanors.
All right, I have another case, 09 SC 84687. That was a Fulton County Superior Court case.
Assault battery.
That case was null prost, and with the reflection that he was currently serving a 5-year sentence with the federal government. #09 SC 84687. I'm not sure what the
I've never had a
other
federal,
case is.
I've never had a 5-year federal case, so no sort.
Okay, I'm just wondering about that case.
I've never
Ms.
had.
Harrison, do you have you, does that show on his report? Shows up on August.
One moment, let me check.
Your Honor, there are 3 co-defendants in that case.
I'm not showing that case as a conviction in his record, Your Honor.
No, that case was null pros, but the case was null pros on October 27, 2021 by Magistrate Judge Brooks. And it says that the defendant is currently on a 5-year sentence with the federal government for a case that happened subsequently. So, I mean, I'll be glad to.
Is that a case that may be outside of Georgia, Your Honor?
That's the only thing I can
From
think of.
possibly North Carolina?
That's the entire, I just literally read you the entire order. That doesn't reference a case number or a jurisdiction.
I see a case out of North Carolina. One of these, I'm not for sure what the code is, maybe pretrial knows.
He has 3 convictions in North Carolina. 2018 resisting officer, it's a misdemeanor. He has a 2018 for possession of stolen goods and resisting officer, and a 2019 driving under the influence.
I'm sorry, what were the 3
And
charges?
I'm showing 2 holds, one in Roswell and the other in Decatur. So he has 2 holds.
But does he have a North Carolina history as well?
He does, and I'm showing 3 misdemeanor convictions out of North Carolina. He has a total of 36 cycles.
Is there
All
a
right.
hold out of Virginia as well?
I'm not showing Virginia.
Okay.
All right. All right, Mr. Kilbo, I'm not satisfied that he has other than that one order, which makes a vague reference to a 5-year sentence, I don't have any indication that he's a convicted felon. So your argument is that based on the lack of a felony conviction, that the bond should be a signature bond?
I am arguing that that is the change in circumstances, that additional knowledge that he does not have a felony conviction, because my understanding from the first time that we were here saying the bond was that there was speculation that the Cobb County case was a felony, but that I've learned that that is not a felony. And in light of all the other circumstances and the argument that I made on the previous occasion, he was not the person driving a car. I think there was a co-defendant who was arrested for, I think about, I'm going to approximate and say 10 driving offenses, reckless driving, failure to maintain lane, fleeing and attempting to elude. That co-defendant, and he was merely Mr. Allen was merely a passenger in that case. So in light of those circumstances, there's no allegation in this that he's done anything violent, although he possessed the weapon. There's no indication that he used the weapon in any violent way or offered or did any violence to the police officer. It's misdemeanor obstruction, possession of the marijuana, drug-related object, and the possession of the weapon. So in light of those circumstances, Your Honor, and the time that he's already served in jail and his prospect of being able to return to the community and return to work, that's why we're asking for a signature bond.
All right, thank you. Ms. Webb?
Your Honor, defense counsel is correct that he was a passenger in that vehicle at that time, but Mr. Allen actually exited the vehicle. Initially, the driver attempted to exit the vehicle while the officer was conducting a traffic stop. And just to apprise the court on the facts of the case, the officer Watson with the Atlanta Police Department was attempting to remove a traffic cone out of the street. He positioned his car on East Paces Ferry in Piedmont so that no cars could pass to ensure that he doesn't get hit or anyone else who may be passing by get hit because there was obstruction in the road. As he had his car positioned at a diagonal state on those 2 roads to remove to remove the cone. That black Lexus, the driver did drive around the officer despite his lights being on. The officer conducted a traffic stop because that Lexus had a tinted tag. When he began the traffic stop, in the car, the driver of the vehicle swung the car door open and the officer told him to stop and to remain in the vehicle. A few moments later, as he was calling for backup, the defendant swung his door open, exited the vehicle, and began walking. And the officer told him to stop walking. He said, "No, I have to go. I got to leave." The officer again commanded him to stop, and he proceeded to keep on walking. At that point, the co-defendant took off in the other car, busted a U-turn in the middle of the street. And now we have a situation where there's a chase in the middle of the day on Piedmont Road where there's high traffic. And the officer is having to employ other units in the area to follow that Lexus while he pursued the defendant, Your Honor. And at that time, the defendant was found with a gun on his person, which turned out to be a Glock 21 45 cal, serial number 82214. The serial number on the handle was 31931, Your Honor, and he was also found with 3.5 grams of marijuana. Granted, this is not a felony conviction, or excuse me, granted the defendant did not have any felony convictions, but we would like to keep in mind the adversarial process of prosecution, Your Honor, that he initially was charged with felonies in Cobb County and was able to negotiate to plead to a misdemeanor, Your Honor. So for those reasons, we would ask that the state keeps the bond as is.
All right, thank you.
Your Honor, may I add one?
Yes,
additional
Mr.
point?
Kilgore.
Yes, the driver of that vehicle, Devontae Webb, bonded out after 2 days on his 10 charges, including the felony fleeing and attempting to elude. Total bond, probably, I'm going to say, I see he's got one bond for $2,500 on the fleeing, $1,000 on a possession of marijuana, and then every other charge was a $100 bond. So approximately $1,000. So, Mr. Allen, please don't speak.
He said he's
You have the right to remain silent.
I'm sorry.
So the person who has had more culpable behavior in this circumstance was able to bond out after 2 days. And for that reason, also, we're asking for a signature bond.
Okay, thank you. Mr. Devine, do you want to say anything in support of Mr. Allen?
Yes,
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, can you just lower your mask for 1 second to identify yourself on screen?
Yes.
All right, good. You can replace your mask. Thank you.
Okay, that's my friend for many years.
You can replace your mask.
It's my friend for many years.
Mhm.
He's really not a bad person. He just he made a few bad choices. But as y'all can see, y'all got all of his records. He's not no felony guy. He just make a little decision. Sometimes they get in trouble, drink a little bit, but you can look at his whole history. He's no threat to nobody. I'm here to support him. I had a stroke, but I'm working to get better. And he's actually one of my employees. I do music. That's all I want to do is just do music to make sure things are right. He helped a lot of people when everybody turned their back on that man. He don't got nobody else but me and a few family members that, that's there for him. And whatever I could do for him, I'm gonna help him.
Yep.
I'm not just gonna turn my back and leave him. I know he good. He got a lot of good things to offer the world. Under these circumstances, it's not looking good. But I'm here to support him, to see it
You
through.
mean the circumstances of being out on the street with marijuana and a gun on him,
Well,
allegedly?
I'm not saying, ma'am,
Yeah.
You the judge. I'm not saying.
I'm just saying that's what the warrant says.
No, I understand. I'm just here in support, but I know he's not a bad guy.
Well, so far, other than multiple arrests and 36 cycles, that's a pretty long history for someone who is not even 40 years old, I guess. So, all right, Mr. Kilgore, did you have anything else to add?
No, Your Honor.
On the obstruction is going to be modified to 500. The possession of marijuana less than 1 ounce, considering the quantity, is going to be $1,000 surety bond. Possession and use of drug-related object, that's going to be a $500 surety bond. And carrying concealed weapon, that's $1,000. Total bond is $3,000 is a surety bond. Condition to the bonds are no illegal drugs. So just make sure that all of them are not on your person. No weapons, no firearms. You cannot have a firearm or a weapon on your person. You cannot have it in any vehicle you occupy. You can't have it in your home, and you can't have it anywhere near you. And this case has been arraigned. Mr. Kilbo, would you like to have it reset to an SAP calendar 2 weeks from today?
Yes, Your Honor.
All right, we're going to reset this to, let's see, 2 weeks from today. That would be March 10th.
Your Honor,
If Mr. Allen makes bond, then the case will be further notice for trial. Otherwise, we will see him on March 10th.
Your Honor, would you need me to prepare a proposed bond order?
If you don't mind, please, thank you. And if you could email that to april.champion@fultoncountygA.gov, april.champion.
And so that I'm clear on the conditions, I mean, I have the total bond of $3,000. I think I understand that. No weapons, no firearms of any kind.
No illegal drugs, correct.
And no illegal drugs. Thank you, Your Honor.
All right.
All right, thank
Yes,
you.
Mr.
All
Divine?
right, so wait, so for everything, how much is the?
It's a $3,000 surety bond. If he goes through a bonding company, they charge between 10 to 15% of the total bond amount.
How much?
That would be anywhere between $300 to $450.
Well, I could give him $450 right now.
Well, he has to go through a bonding company. Or he can put up 3,000 surety and cash, and that would go through the sheriff's office.
So if I got 500 and all her stuff, I can get him out.
Yes, sir.
All right.
Between $300 to $450 to a bonding company. There are lots of them around the jail.
Can he hear me?
Can he hear you?
Yeah.
Mr. Allen, he should be able to hear you. Yes, sir.
All right. Dennis,
Thanks a lot, sir.
I'm gonna get it together. Look, we can't have no more problems, man.
Yes, sir.
You know what I mean? You gotta do, you know what I mean? Let's just change the world with music, man. You gotta give something back.
Thank
I'm gonna work on that now. I got the money now. I gotta get one of my family members. But I got the money in my pocket now. But this is the last time, man. I love you. Hold your head up.
you too, man. All
All
right.
right.
Thank
sir.
you, Mr. Devine. Have a nice day.
Next, we got position number 5, Mr. Gray.
Position number 5, I have Mr. Christopher Dexter Gray, accused of battery in 22 CR 000680E, allegedly from December 7th, 2020. Mr. Gray, you've been advised of your right to remain, well, you've not actually, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Finling. And Mr. Finling, this is going to be a non-negotiated plea, is that correct?
That's correct, Judge.
All right. Mr. Gray, I'm going to first hear from the prosecutor as to what recommendation they are going to offer you. And then I will hear from your attorney. I will let you know which recommendation I will accept before we proceed with the case. Ms. Webb?
Yes, Your Honor. In this case, the state is recommending 12 months to serve, 60 days, credit for time served, 192 days, balance probated, a stay away from 234 Memorial Drive Southwest, no further contact with Lonnie Scott, that's Lonnie, Lonnie, Scott, SCOTT, 8-week anger management, and 50 hours of community service. Your Honor, at this issue, the defense has an issue with balance probated versus suspended. We are opposed to the balance being suspended so that the defendant can complete the 8-week anger management class. In this case, the defendant approached someone that lived at the same apartment complex as him and punched him in the face for smoking a cigarette on the second balcony of that apartment building, Your Honor. This does appear to be wholly random, Your Honor, as the victim did not indicate that they had any prior connections outside of just being at that same residence, Your Honor. Addition to, we are asking that he complete these the conditions for probation because of his history as well, Your Honor. He has several arrests, including aggravated battery from 2011, 2007, several probation violations dating back from 2003, with the latest being 2015, Your Honor. He has open cases for aggravated battery that stems from an August 2021 event, Your Honor. And considering he has several convictions as well, including aggravated assault from 2018, with 33 cycles and 1 cycle out of North Carolina, we are asking that the balance do not be suspended and that the defendant is ordered to complete those conditions for probation.
All right, Mr. Finley?
Yes, Judge. And we are just asking for the 50 hours of community service to be waived. And then once we are not opposing the 8-week anger management, although we are asking for the fees to be waived. We're just asking that once he completes whatever conditions Your Honor may choose, that it become suspended or at the least not reporting. Mr. Gray's most recent job was at Burger King. He is looking for, he's going to need more permanent housing, although he did give me an address, 89 Ellis Street. So we are asking to remove the community service so Mr. Gray can focus on rebuilding his life, rebuilding his finances, and kind of getting back on track and making sure that he doesn't return.
I'll accept the defense recommendation. I will waive the community service, but he will be required to complete the 8-week anger management program. He will report to probation every month, and I will waive probation fees for 4 months. If the anger management program is completed, probation will be on a non-reporting basis. Is that something that he would like to consider?
Does that sound good, Mr. Gray?
Yes, ma'am. Yes, sir.
All right, sir, please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
All right, and Mr. Findling, do you stipulate to venue and ID?
Yes,
You may
Judge.
stand down. Thank you. Mr. Gray, are you under the influence of any kind of medication or alcohol?
No, ma'am. We have medication. I take medication.
All right, is that impairing your ability to think clearly presently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation of your attorney?
Yes, ma'am.
If you decide to take this plea of guilty to 1 count of battery, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's evidence and present your own defenses, as well as confront your accuser and examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 30 days. Your time at the jail for this particular case is over, but you would have to, once you're released, I don't know if you have any other holds. Mr. Finling, I suspect he does. Does he have any other holds?
I'm not positive, Your Honor. Yeah, I'm not 100% sure, Judge, but I can look into that.
All right, Ms. Champion or Ms. Lewis, if you can look and see if he's got any other holds. If you've resolved all your holds at the jail, then once you are released and placed on probation, you must report to the probation office within 48 hours of being released. I will waive your probation fees for the first 4 months of your release, during which time you would need to complete an 8-week anger management program at your expense. At all times, you are to stay away from 234 Memorial Drive, Southwest Atlanta. You may return to that location 1 time only to retrieve any personal belongings you may have. On this one-time visit, you must go with a police officer. That's the only way you can visit that location. Do you understand?
Yes, ma'am.
At all times, you have to also have no contact with Lonnie Smith. You have to stay 200 yards away from him, not communicate with him in any way, form, or manner, in person, through a phone, through a computer device, or through a third party. Once you've completed the 8-week anger management program, your probation will be non-reporting. Do you have any questions about your sentence, sir?
Yes, how much would the probation fees be, that I have to?
Your probation fees presently are waived for the first 4 months. If you complete the 8-week anger management program, your probation will be non-reporting after 4 months. But if you take longer than 4 months to complete the anger management classes, then your probation fees will be about $50 a month.
Okay.
Because this is for Christopher.
This is for
Gray.
Christopher Dexter Gray. Gray
He
with
does
an
have,
A.
does have a hold on him. He has a felony hold. And he has a surety bond of $5,000 on it.
That's what I thought. All right, Mr. Finley? He has to resolve his felony hold before he can be placed on probation.
Yeah, I'm just seeing that now. Thank you, Judge.
All right. Mr. Gray, do you understand your circumstances?
Yes, ma'am.
All right, sir, that concludes your case. Thank you.
Thank you. I have an update on position 7 and 8. They got released last night. Mr. Myers.
All right, thank you. Position 7 and 8, Mr. Joshua Myers is further noticed for trial. Who do we have in courtroom 2, please?
This is position 1 on the add-on, Mr. Beasley.
All right. This is Terence Oliver Beasley, is that correct?
Yes, ma'am.
All right, Mr. Beasley has 2 cases, 21 CR 001468Y, accused of 2 counts of misdemeanor stalking, willful obstruction of an officer, loitering and prowling, and criminal trespass, allegedly from March 26, 2021 in Fulton County, Georgia. Second case is 21 CR 003906Y. Mr. Beasley is accused of battery, domestic violence from October 6, 2020, allegedly in Fulton County, Georgia. Mr. Beasley has been advised of his right to remain silent, and his attorney is Mr. Finley. Is that correct?
I am representing him.
Oh, Ms. McLeod. Okay.
Yes.
Your attorney is Ms. McLeod. And with regard to this particular case, the add-ons, Ms. McLeod, what's the announcement, please?
The announcement is that my client is ready to take a plea.
All right. This is a
It's
negotiated plea?
non-negotiated, yes.
I'm sorry, non-negotiated or negotiated?
Non-negotiated, Your Honor.
Non-negotiated, all right. So Mr. Beasley, first, before I place you under oath, I'm going to hear the recommendation from the prosecutor, and then I will hear your attorney's recommendation. I will let you know which option I will select before we proceed, keeping in mind that I also have the option of not accepting either plea offer and moving the case forward for trial. Do you understand, sir? Okay. Ms. Arnold, good morning. What is the recommendation?
Yes, Your Honor. Good morning. So the state is requesting 12 months probation, credit for time served, 333 days, no further contact with Diamond, D-Y-M-O-N-D, Hutcherson, spelled H-U-T-C-H-E-R-S-O-N, or Katie, spelled K-A-T-Y, Kosari, spelled K-A-O-S-A-R-I, a stay away from 3380 Peachtree Road Northeast in Atlanta. And that is the recommendation for position number 1 for the add-on 21 CR 001468Y.
Is this a concurrent sentence for each count?
Yes, Your Honor.
So it would technically be a time served then for position 1.
Well, it was our intent that he serve the remaining. Oh, because you're saying for the jail for the 2-for-1.
Yes.
Okay. Okay, Your Honor. It was our intent that he had probation for the remaining of the 365 days, but I do understand what you're saying. So I guess essentially, yes, it would be time served.
All right. And position 2?
It is the same recommendation, Your Honor. 12 months probation, credit for time served, 333 days.
And does position 2 run concurrent with position 1?
Yes, Your Honor. but there is a different victim in that. So no further contact with Sade Holston. Sade spelled SHADAE, last name Holston, HOLSTON, with a stay away from Bent Creek Way Southwest, Building M.
Bank Creek Way, Southwest Atlanta. And have these alleged victims been advised that Mr. Beasley would be completing his time at the jail and most likely be released unless he's got any other holds?
Your Honor, we were able to speak with, we were not able, we didn't have contact with Miss Kosari or Miss Hutcherson. We were able to speak with Miss Holston. And we did advise her that we were going into a negotiated plea. She did state that she would be on Zoom today, but I'm not sure that I saw her. But she just made it clear that she just wanted it to make sure that there was no further contact with her.
All right. Ms. Hutcherson, Ms. Kosari, and Ms. Holston, if any of you on the Zoom proceeding, this is your moment to start your video and unmute your screen. Otherwise, we are proceeding. All right, we will proceed. Ms. McLeod?
Yes, Your Honor. Based on what the prosecutor has said, we had come into this as a non-negotiated plea, but my only issue with it would be that I felt like since my client had already served 336 days, that it should just be straight time served. And it seems to me like if that is going to be the case, then we are fine with him taking that plea. My only issue was that there was talk of him continuing to be on probation, and I thought that would be setting him up for failure in the future. So that was my issue with it.
Well, the way that this whole thing will fail for him is if he has any contact with Ms. Hutcherson, Ms. Kosari, and Ms. Holston. And if they have been advised to obtain a protective order against him, well, we get to start this whole rodeo all over again. So Ms. McLeod, would your client like to proceed with this plea? Basically,
yes, Your Honor. He would.
All right.
He does understand the no contact provisions and he's fine with those.
All right. Mr. Beasley, if we can unmute Courtroom 2, please.
Yes, ma'am.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
If you decide to move forward with this plea, sir, as I've already advised your counsel, is that if you engage in any kind of communication with the 3 alleged victims, I have no way of gauging what's the nature of that contact and if you may be in violation of any protective orders they may have obtained against you separately from Superior Court. But in either event, you run the risk of coming back to jail.
Okay.
So you are on notice right now that the best thing for in your best interest would be to stay away from these 3 individuals and to move forward with your life without having to come back to us. Because no matter how much you like the place, we really don't want you back.
Okay.
Mr. Beasley, with regards to both cases, first of all, Ms. McLeod, we're going to deem this to be a negotiated plea. Do you stipulate to the factual basis, venue, and ID for both cases?
I do, Your Honor.
All right. Mr. Beasley, you're under oath. Are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, ma'am.
And are you satisfied with the representation of your attorney?
Yes, ma'am.
If you decide to move forward with these 2 cases and enter a guilty plea, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to be able to challenge the state's evidence in their case, and examine witnesses and confront your accuser. You would also have to waive your rights to have the state try to prove these charges against you beyond a reasonable doubt. Are you prepared to waive and give up these rights?
Yes, ma'am.
Is anyone forcing you or inducing you to take a plea?
No, ma'am.
All All right, sir. With regards to case number 21 CR 001468Y to the 2 misdemeanor charges of stalking, 1 count of willful obstruction of an officer, loitering and prowling, and criminal trespass, how do you plead?
Guilty.
To case 21 CR 003906Y, 1 count of battery, domestic violence, how do you plead?
Guilty.
Your sentences are going to run concurrent for both cases, and the sentence is going to be 12 months to serve. Well, I guess 12 months to serve 12 months, credit for time served 336 days. Given the 2-for-1 ratio offered by the sheriffs, your time at the jail has been deemed as served. You'll be released within 24 hours as long as you have no other cases holding you at the Fulton County Jail. Once you are released, you are recommended that you stay away from 3380 Peachtree Road in Northeast Atlanta. And it's also recommended that you stay away from Ms. Hutchison, Ms. Kosari, and Ms. Shade Holston. The state is on notice. They should reach out to these 3 victims again and advise them that Mr. Beasley has served his time and is released from jail for these 2 cases, and that if they seek any additional protection, they should obtain a protective order from Superior Court of Fulton County or the appropriate Superior Court. All right. Anything else, Ms. McLeod?
No, Your Honor, that's everything.
All right. That concludes these 2 cases. Thank you.
Thank you.
Your Honor, that concludes my business before the court. May I be excused?
Yes, Ms. McLeod, you have a good morning. Thank you.
Thank you. Same to you, Judge.
I'm sorry, Ms. McLeod. Oops, she's already disappeared.
I'm here. I'm still here, Your Honor.
Okay. Ms. Champion just wanted you to remind you to please send the plea paperwork to her as soon as
I will
possible.
do that, Your Honor.
All right. Thank you.
You're welcome.
All right. Thank you, Mr. Beasley. Best of luck.
Thank you very much, Judge.
All right. Okay, next case, please. I'm not certain. Courtroom 2, who do we have next, please?
We can do the competency case, position 9, Mr. Sabir.
Okay. I have a Lori Thornton. Are they waiting on the particular case on the SAP calendar?
Yes.
All right. Is this a competency case?
Yes, ma'am, we think so. This will be his 3rd time.
All right. Who's the
Judge,
name of?
Judge, which position? This is Derek Howard. Can we hold off for a minute? I need to confirm something on the competency calendar cases. Well, are we finished with the SAP calendar?
I assume so. Courtroom 2. Do we have anyone else on the SAP calendar? All right, before I begin the competency calendar, I am going to just go over the SAP.
Yeah.
All right.
11, Mr. Stewart.
Judge 4 North just came in. I think they got people still on the SAP.
All right, thank you. We are still on the SAP calendar and we're going to start with 4 North. And we're going to hold on the competency calendar until Mr. Derek Howard's ready. Who do we have at 4 North, please?
Position 11, Mr. Stewart.
People in this thing like they're okay, you know.
Oh, Mr. Thornton, if you could mute your screen, please. I don't want you to say something that may be confidential. Thank you.
Good morning, Your Honor.
Good morning. We have Keon Burley Stewart, and he is case 22 CR 000670B. Mr. Stewart's accused of battery from a February 2nd, 2022 incident. Mr. Stewart, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. Mr. McLean, this is position number 11, and I understand that this is going to be an arraignment and a bond hearing. Is that correct?
Correct, Your Honor.
All right. Would you like to me to read the accusation, or do you waive a reading of the accusation?
It won't be necessary. I've explained to him the details in the accusation.
All right. Mr. Stewart presently has a $5,000 good bond that was issued on February 10th, 2022 with no contact and a stay away. So let's proceed. Mr. Stewart, I understand that you will be pleading not guilty to this one count of battery. Your attorney has advised us that you're going to move forward with a request for a trial. So presently you are accused of this misdemeanor offense allegedly occurring on February 2nd, 2022. Given this misdemeanor offense, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecutor succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Guilty.
Repeat.
Not guilty.
Thank you. Your case has been arraigned. You are presently on a $5,000 good bond. Mr. McLean, he's been in custody now for about 17, 18 days. Why are we seeking a modification?
Your Honor, he has on his booking sheet a felony in which he's represented by Ms. Gowdy of our office. And there is a substantial bond on that, really. He has this out-of-state extradition matter. I don't know that they're actually going to activate that. I believe he has waived extradition, if my information is correct. On this particular case before the court today, he is pleading not guilty. He intends to go to trial. And because there is the other case, he would like to ask the court for a signature bond, or in the alternative, a $1,000 surety bond.
Mr. Sproul, we have.
Hang on. Mr. Derek Howard, I'm sorry, if you are in a conversation, we can all hear you. Okay, there we go. Thank you. Sorry about that, Mr. McLean, you may continue.
Not a problem. So he would like to ask for a signature bond, or in the alternative, a $1,000 surety bond, which would be more affordable to him for this matter. He assures me that he understands exactly when to come to court, which is when either mail notice comes to his address, which is Milwaukee. He has family there, or he can check every couple of weeks with the clerk and make sure he doesn't miss a court date.
And I'm sorry, how much are you asking for?
Either a signature bond in any reasonable amount, or a $1,000 surety bond.
Okay. Ms. Arnold?
Yes, Your Honor. So the state is requesting that the bond remain with the conditions as stated as well. Your Honor, this incident happened on February 2nd at the Northside Drive address. Ms. Sims said that she and the defendant had been in a relationship on and off for about 2 years. The defendant flew here from Wisconsin to come and get his property from her apartment. While the defendant was laying in the bed, Ms. Sims' young son stepped on him, which made him upset. A few minutes after that, the defendant started to hit and kick Ms. Sims in the head. Ms. Sims then grabbed her son and left. Officers were able to see bruising on the left side of her face and the inside of her mouth. Your Honor, we do believe that this defendant will reoffend based on his history. He has a 2017, and I'm sorry, Your Honor, because I'm going to say arrest. 2017 arrest from Milwaukee for battery, a 2019 arrest for possession with intent of THC, maintain drug trafficking place, possession of a firearm, criminal damage to property, disorderly conduct, and carrying a concealed weapon. He also has a 2020 probation violation, 2021 probation violation, and the latest of last year from June of 2021 probation violation, possession of firearm by a convicted felon, and 4 counts of bail jumping. In addition to the open case that Your Honor has already mentioned for theft by taking, and for purchase, possession, or having controlled substance. That case also involves the same victim with the theft by taking, Miss Kateria Sims, spelled Kartia TERIYA. So Your Honor, we do believe that the defendant will reoffend, and we do believe that he is a flight risk as he does not have a residency here in Georgia, and he was only here to visit from Milwaukee. So we would request that the bond remain the same, Your Honor. Thank you.
Very expensive visit. Bond is modified to $2,500. No further contact with Ms. Katria Sims, and he's to stay away from the Northside Drive location. No illegal drugs, no weapons, and no firearms. I understand that he has waived extradition, so Milwaukee will need to come down and pick him up to address his outstanding charges in that particular city or state, Indiana? No, it's not.
Wisconsin.
Wisconsin, sorry. And then if that address is still correct, it's going to be his duty to make sure that we have all his current and updated addresses so that he can show back up in court in Georgia, whether it's in person or in Zoom, via Zoom. And failure to do so will result in a bench warrant being issued. And these bench warrants, whether we like it or not, tend to go nationwide. Okay, Mr. McLean, you can submit a proposed bond, modified bond order to and email that to April Champion. If he makes that bond, then Milwaukee or Wisconsin will be alerted to pick up Mr. Stewart and transport him back to that particular state. Unfortunately, he cannot be released on that fugitive hold.
Very good, Your Honor. Thank you.
Thank you.
Yes, we have number 15 and 16, Mr. Williams.
Thank you. Mr. Kilball, what are we doing with Mr. DeMonte Williams, please?
We have a negotiated plea.
All right, thank you. We have Mr. DeMonte Williams, two cases, 21 CR 002943B, accused of battery domestic violence from a June 20th, 2021 incident. We have a second case, State versus DeMonte Williams, 22 CR 000411B, accused of battery, domestic violence, and criminal trespass from a January 26, 2022 incident. With regards to both these cases, Mr. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. William Kilball. We are going to address a negotiated plea for both cases. So if you could please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right. Mr. Ms. Arnold. Ms. Arnold, we have both cases. If you'd like to recite the state's offer as well as indicate whether they are concurrent or consecutive.
Yes, Your Honor. For case number 21 CR 002943B, the state's offer was 12 months to serve 60 days, credit for time served 28 days, no further contact with Desiree Trotman, spelled DESIREE, Trotman, spelled TROTMAN, a stay away from 835 Oglethorpe Avenue, FVIP, 40 hours community service, no drugs, alcohol, or weapons, and the balance is to be probated. This is concurrent to case number, 22 CR 000411B. And in that case, it was 12 months to serve, 60 days, credit for time served 28 days, stay away from the 835 Oglethorpe Avenue, no further contact with Ms. Desiree Trotman, FVIP, and 40 hours of community service, no drugs, alcohol, or weapons.
All right. Do they share children?
They have one child together, Your Honor.
All right. Mr. Kilball?
Your Honor, we would ask you to accept the plea as negotiated. I will just say that Mr. Williams has some medical difficulties, and he has a plate in his head from an accident several years ago. He suffers from seizures. He really needs to be out of jail. And I have explained to him, and I believe he understands that the only reason that he's in jail right now is because he made the foolish choice to go over to Ms. Trotman's address after Your Honor ordered him not to. And because of that, he's been sitting in jail for 28 days and he's entering this guilty plea and he's going to have to do all these things. And that the gravity of the, if he chooses to go over there again to violate this, Your Honor's probation order, he understands, I believe, based on our conversation, he understands how foolish that would be and that it's going to result in him being in jail, and it's going to be much more difficult for myself or another attorney to help him get out of jail.
Thank you for that, Mr. Kilbo. Also, with regards to the child, he's going to have to legitimate the child, and if he has not done so already, and get a superior court order to determine visitation and any custody issues as well. I'm not going to permit him to have any contact with the child unless he goes to superior court to legitimate the child. Mr. Williams, is that something that you would like to consider?
Like consider as well. I was
only address the issue about the child. If you accept this plea, you have to stay away from Oglethorpe Avenue. You cannot have any communication with Desiree, no communication at all. And you cannot see her, and you cannot see the child. Once you're released, you have to go to superior court, file a legitimation action, and then the superior court judge will then let you know when and where you can see your child. Do you understand?
I understand. Thank you.
All right, and your attorney is absolutely right. If you have any contact with Desiree, if you're seen anywhere near the Oglethorpe location, all she has to do is report you and your probation could be revoked and you could face a felony charge of aggravated stalking.
I'm not trying to go back near her, man.
Well, as long as you understand that. Mr. Kilbo, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
All right. Mr. Williams, I can't remember now whether I placed you under oath. Let's do that again. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Mr. Williams, are you under the influence or have you taken any kind of medication or alcoholic beverages?
I say seizure medication.
And has this interrupted or caused you not to understand what's going on?
No, man, I haven't.
Are you able to understand the proceedings so far? You need to say yes or no.
Yes, ma'am.
And have you understood what your attorney has explained to you?
Yes, ma'am, I have.
Are you satisfied with this representation?
Yes, ma'am.
If you decide to plead guilty to these two charges, to these three charges, you will have 2 counts of battery domestic violence on your record. If you get arrested again in the future for battery domestic violence, that is an automatic felony charge. Do you understand?
Yes, ma'am, I understand.
Is anyone forcing you or inducing you to take a plea today?
No.
If you decide to take this plea, you would have to give up your constitutional rights to go back to court, to have the assistance of counsel, to have a trial before a judge or a jury. You would also have to give up your rights to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt for both the cases. Are you prepared to give up all these rights?
Yes, ma'am. Can I speak upon something?
Do you?
I'm sorry. Even though as the point of the case, she even asked me to come over to help out with the rent, but as her laptop, she said that I destroyed her laptop, and when we went to jail last year, the doors unlocked, and I could not.
Mr. Williams, Your Honor, can I have a moment to speak with Mr. Williams by phone?
Certainly. Ms. Lewis, if you could place 4 North and Mr. Kilbo in a breakout room, please. Thank you.
Will do.
Thank you. Courtroom Two, who do we have, please?
Yes, we have position 17, Mr. Young.
All right.
Okay. All right.
We have Raymond Dwayne Young, accused of battery in 22 CR 0000685F from a November 15, 2020 incident. With regards to this particular case, Mr. Young, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is either Mr. McLean. Who's your attorney, Mr. Young?
Mr. Mark McLean.
All right.
Here we
Mr.
go.
McLean. All right. Mr. McLean, I understand your client wants to plead not guilty and address bond. Is that correct?
Correct, Your Honor.
All right. Do you waive a reading of the accusation?
We do. We've read the accusation, and I've explained to him the details of the date and the accusation elements.
All right, thank you. Mr. Young, you've been accused of one misdemeanor offense of battery. Upon your entry of a not guilty plea, the case will be scheduled for a trial. At the time of the trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt. If the state succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
No contact.
All right, Mr. Young, I understand from your attorney that you want to challenge this charge in a court of law. So are you pleading not guilty?
Yes, ma'am.
So how do you plead to this case?
No contact, ma'am. Context.
That's a new one. Perhaps a breakout session, but I can explain to him that a guilty plea is a unnegotiated or negotiated plea that results in a sentence today, or a not guilty plea goes ahead to trial, which is what cases are designed to do unless they're stopped. And of course, today's thing for me is a bond request.
All right. Mr. Young, do you want a trial in your case?
Well, if I can get the bond request, ma'am, I'll take the bond request, ma'am.
All right. So, Mr. McLean, if you could call the jail at 404-612-2392. And Mr. Young, please step aside. Your attorney is going to speak to you via phone.
Thank you.
Do you have another case in courtroom 2?
We have position 13, Mr. Talley.
Mr. Talley, Mr. McLean, is that your client?
It is, Your Honor. That's a negotiated plea.
All right, before you go and talk to Mr. Young, just let's take care of this, Mr. Talley. Mr.
Certainly.
Talley is Elmas Devon Talley, accused of criminal trespass in 22 CR 000-694J. Mr. Talley, this is going to be a negotiated plea. You've been advised of your right to remain silent. Your counsel is Mr. McLean. This alleged offense occurred on February 11, 2022 in Fulton County, Georgia. Mr. Talley, if you'd please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Arnold, what's the recommendation for Mr. Talley?
Yes, Your Honor. The recommendation is 12 months to serve 14 days, credit for time served 14 days, stay away from 227 10th Street Northeast in Atlanta, and the balance is suspended.
What location is that? Is that a big building?
Your Honor, that
Right
is
from the park.
Blake's.
It's a nightclub.
That's right. I was trying to remember what it was. Okay.
Right.
Okay. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Talley, are you under the influence of any kind of medication or alcohol?
No, ma'am.
Are you satisfied with the representation of your counsel, Mr. McLean?
Yes, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
If you decide to take this plea today, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to challenge the state's case, present your defenses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Yes.
Your sentence is time served. You are to stay away from the location known as Blake's at 227 10th Street in Atlanta, Georgia. If you return to that location, the management may have you arrested again. So please keep that in mind. Understood?
Yes, ma'am.
All right, you're free to go. Thank you.
Ma'am.
Mr. Kilbo, we are returning to your client's case, Mr. DeMonte Williams.
Yes, Your Honor.
All right, and with regards to DeMonte, has he understood the terms of the plea, including the legitimation issue?
Yes, Your Honor.
All right.
I had
And now
one additional request for the plea. That would be, could Your Honor please waive the probation supervision fees? He is going to have to pay for the cost of the FVIP program, and potentially if he legitimates the child, or if the mother requests child support, files for child support, then he's going to have to pay to support that child. And he is not of great financial means, and suffers from, as I said, he has a metal plate in his head from an accident and suffers from seizures, making it difficult to earn very much money.
I will waive the probation fees for the year, but he will have to enroll in the domestic violence intervention program within 60 days of being released and report to probation within 48 hours of being released. Is that acceptable?
Yes, Your Honor.
All right. Mr. Williams, if you want me to waive your probation fees as a condition to your probation, you must enroll in the domestic violence classes within 2 months of being released. If you don't, well, then you give us a good reason to bring you back to jail.
Understand.
All right. So, Mr. Williams, we will proceed with your plea. You've already been sworn. As I've already understood that you are satisfied with the representation of your counsel and that you do understand the proceedings so far. If you decide to plead guilty to these charges in these 2 cases, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to confront your accusers, to examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. As mentioned, are you prepared to waive all these rights?
Yes, ma'am.
How do you plead to 1 count of battery domestic violence against Desiree Trotman on June 20th, 2021?
Guilty.
How do you plead to 1 count of battery domestic violence and criminal trespass from an incident date of January 26, 2022?
Plead guilty, ma'am.
All right, I'll accept your guilty plea to these charges. Your sentence is 12 months to serve 60 days, credit for time served 28 days. You have 1 more day to serve at the Fulton County Jail, after which you will be released within 24 hours. You will have to report to your probation officer no later than next Tuesday, which is going to be it's going to be March 1st, first day of March. So make sure you report to probation on March 1st, 2022. Understood?
Yes, ma'am. March 1st, yes, ma'am.
All right. And the probation office is at 132 Mitchell Street in Atlanta, Georgia. You will get paperwork to that effect. Yes, sir?
What time I have to go see my probation?
Anytime on March 1st before 5 o'clock.
Yes, ma'am, I will.
All right. Now, with regards to the rest of the sentence, these sentences will run concurrent for both cases and all the 3 charges. As I've said, you've got 1 more day to serve at the jail, after which you'll be released. While you're on probation, you shall have no contact with Desiree Trotman. And if you haven't understood that before, understand it now. Stay 200 yards away from her. You cannot communicate with her in person, through a third party, through a phone, through a computer device. If she invites you or sends you any messages, you are required by court order to ignore all of them and make sure you stay completely away from her. Understood? You're also to stay away from 835 Oglethorpe Avenue in Atlanta, Georgia. You're not to be seen within 200 yards of that location.
But even like I go to London Tech as well, and I have to go to classes like every like 11 o'clock to 12 o'clock afternoon.
So what's that got to do with 835 Overthorpe Avenue?
Because it's at the West End train station.
Repeat that?
It's at the West End train station. I got to test the 95 to get the class.
As long as you're not in the complex at 835 Overthorpe Avenue, and if you are just there to change buses or change trains, that's fine. But if you make any movement towards that location, try to enter that location, you're going to be in trouble.
I'm not going back that way at all.
All right?
Yes, ma'am.
Within 60 days, within 2 months of being released, you are to enroll in the Domestic Violence Intervention Program. If you can enroll right away, that's great, but no later than 60 days. And you're to make sure your probation officer knows that you're already enrolled in the program and that you are attending the classes. You're also to complete 40 hours of voluntary community service. And at all times while you're on probation, you're not to consume any illegal drugs, no alcoholic beverages, and not possess any weapons or firearms. You understand?
Yes, ma'am. I understand.
Your probation fees are waived, but you will report to probation every month until the 10 months of probation is over.
I'll do that.
All right, that concludes your case. Thank you.
You're welcome.
Thank you, Mr. Kilville.
May I be excused, Your Honor?
Yes, sir, you have a good morning. Thank you. Courtroom 2, is Mr. McLean ready to address his case?
No, Mr. Young is still on the phone, but can we just go to our competency, which is position 9, Mr. Sabir?
Mr. Howard, are we ready to
Yes.
proceed?
Yes,
All right.
Judge. Mhm.
Thank you.
I need to get a clarification. Normally, these are not recorded live on YouTube. Am I correct?
Yes, we'll need a breakout to discuss it, Judge.
Also,
All right.
we'll keep it streaming then.
Who wants to be in the breakout room for position 9 on the competency calendar?
Judge, I think me, Mr. Hopkins, and Miss Amin Williams, our social worker, should be sufficient.
Okay.
All right, Miss Lewis.
Okay.
And courtroom 2 is not going to be in the breakout room, please.
No.
All right, I have Miss Kasha. We are back in courtroom 2 to address Ismail Sabir. Is courtroom 2, is Ismail there? Okay, there he is. Okay. And is Mrs. Sabir present as well? Miss Shah Sabir? Miss Shah Sabir, if you could please start your video and unmute your screen. All right, waiting on Mrs. Shah Sabir to, there she is. Unmute your screen, okay. Mrs. Sabir, my name is Judge Lal. Do you mind if I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mrs. Sabir, we're going to release Ismail on a signature bond, but with some very strict conditions. And I understand that currently in your same household, that Zara lives there with Zoris, is that correct?
Yes.
And does Zara's husband live there too?
Yes.
And what's his name?
Brandon.
Is that Brandon?
Brandon.
Brandon Primus?
Promise. P-R, I think it's spelled Primus.
Okay, all right. So Brandon and Zara are Zoris's parents, correct?
Yes.
Okay, thank you. All right, after a sidebar with counsel and social worker with regards to the case of Ismail Sabir, Mr. Sabir is going to be granted a $3,500 signature bond through the jail. He will be released within 24 hours to the care of Shah Sabir and her spouse.
I'm sorry, please. When I logged in to the Zoom, that name was there. But Shah is one of my sons.
Oh, I'm sorry. What's
And
your name?
I will spell it for you. It's spelled S-A-F-I-Y-Y-A-H.
Sophia?
Yes.
Okay. All right. Mr. Sabir, Mr. Ismail Sabir will be released to the, you can mute your screen, Ms. Sophia.
Okay, thank you.
Mr. Ismail is going to be released on a $3,500 signature bond through the jail to the care of Ms. Sophia Sabir and her spouse. Ms. Sophia and her spouse will be primarily responsible for the care and the security of Mr. Ismail Sabir and make sure that he's compliant with his medical treatment and any medication is prescribed.
Judge, pardon, please.
No more interruptions, Ms.
I'm not married. I don't have a spouse.
Oh, okay.
Yes,
Thank you.
right, Judge. The spouse is right, not her, not her spouse, Judge.
Okay, so sorry about that. Thank you. Moving on. Within 30 days of being released on the signature bond to the jail, Mr. Ismail must make an appointment to obtain the appropriate treatment that is required for his particular condition. And while he's out on the signature bond, he shall be compliant with all medication and all treatment that is issued to him from his healthcare provider. And he shall have no further violent contact with Sophia Sabir, with a minor Zoris, with the adult Zara Sabir or Zara Primus, and with Brandon Primus. And more importantly, also Miss Sophia, Miss Zoris cannot be in your care. Anytime that Zoris and Ismail are in the same home, you must make sure that Zoris Primus is not alone with Ismail. Furthermore, Zara Sabir and her spouse Brandon must make sure that they are the primary caretaker of the minor child. In other words, you cannot babysit the child. You cannot be in a sole care of the minor child. Do you understand? It is going to be completely his parents' responsibility to make sure that he's not alone with Ismail. All right. The next court date for this case is 60 days from today, and that would be April 21st, 2022 at 11 a.m. via Zoom. If Mr. Ismail Sabir gets in trouble with the law again, or if he's not medically compliant, or if there's any violent altercations with any of the family members in his home, he will be sent back to jail and the $3,500 signature bond will be revoked. We will readdress this case on April 21st to see, to make sure of his progress and to make a determination of this case. Any questions, Ms. Sophia? Any questions, Ms. Sophia?
No, ma'am, I have no questions.
Thank you. All right, Mr. Howard, Mr. Hopkins, and Mr. Ismail, this case is concluded.
Thank you, Judge.
All right, Mr. McLean, we are returning to your client.
Thank you. Yes, we talked about no contact was not a legal phrase we use. Well, it is, but not in this context.
What position number was that case? I'm sorry. Position 11, right?
17, I believe.
17, sorry about that. Okay. 2, 3 calendars, there we go. All right. Mr. Young, if we can unmute Courtroom 2. You've already had a conference with your attorney with your regards to your decision for arraigning the case. With regards to the charge of battery, as I've already explained to you, how do you plead?
Not guilty, ma'am.
Your case has been arraigned and further notice for trial. Mr. McLean, what is your argument for bond modification?
Your Honor, he has a stable address that he's been at for years with his mother's address. Her name is Rhonda Young at 3401 Mertis Street, MERTIS, apartment 137, Shreveport, Louisiana, 71109. And I believe that is also what is shown in his jail bookend type screens. Your Honor, the case in question references, by coincidence today, Blake's nightclub or tavern at 10th Street in Atlanta. It references an alleged date of occurrence of November the 15th, 2020, about 13 months or, well, 15 months or so ago, approximately. He says, it's not me. I wasn't here. I was in Shreveport, my hometown. At that time, if it was a work day for him, he would have been at Burger King working his job. He will return to court anytime the court notices him. He will watch his mail. He'll check with the clerk periodically. And he came to us from municipal court on some other matter, disorderly conduct, as a matter of fact. And now I see this accusation against him, 22 CR 000685. Is that an F? I believe that's an F. And in the police report that's attached to that, a young lady said that a Paul Charette, CHARETTE, whose race is listed as being white/unknown, was identified by her from a video as being the person who struck her in a nightclub one night in November of 2020. I'm at a loss to hook that up with Mr. Raymond Young at this time. Perhaps there is a document in which the state is saying that that's him, but I haven't seen it, and that is totally confusing to us. At any rate, he says, it wasn't me, I wasn't here. But he will pay attention closely to his address, his mail, and he'll come back to court, he says. So we would ask the court to take him at face value on that and to look at the possible discrepancy as to race in the police report and think that maybe this is something worth taking a chance on with a signature bond. We'd love to do that.
Ms. Arnold or Ms.
Yes, Your Honor. So the state is asking that the bond would remain. Your Honor, this incident did happen at Blake's, located on 10th Street. Ms. Burgert advised that she was with some of her friends. Burgert is spelled B-U-R-G-H-A-R-T. And first name Kristen, spelled K-R-I-S-T-I-N, was with some friends at a nightclub talking to two males, one of which was the defendant. The defendant became angry and struck her in the face. Officers were able to observe redness and mouth swelling. Your Honor, we do believe the defendant will reoffend based on his history. He has arrest from Louisiana from 2010 for aggravated battery, July of 2012 for a simple battery, July 31st of 2012 for a simple battery, from November of 2012 resisting an officer and battery of an officer, and then a March 2017 simple battery, Your Honor. So we do believe the defendant will reoffend based on his history, and we do believe that he is a flight risk since he is not a resident of Georgia. So we would ask that the bond will remain with the conditions of the stay away and no further contact with Ms. Burgart.
Mr. McLean, does your client have a Atlanta address now or Louisiana? Put your hand down, sir.
Louisiana, Your Honor.
Put your hand down, Mr. Young. Put your hand down.
Is the state saying that he is Paul Charette or the Paul Charette is him?
I don't know, but what I'm asking you is, does he have a Louisiana current address or a Atlanta, Georgia address?
Shreveport, Louisiana, Murder Street, at that apartment.
All right. Bond is set at $3,000. It's a signature bond through the jail to stay away 200 yards away from Blake's at 227 10th Street in Atlanta, Georgia. He cannot return to that facility. No contact with Kristen Burkhardt. He needs to maintain a current address and contact information with the court at all times. And he needs to appear when summoned to court. No illegal drugs, no weapons, and no firearms.
Very good. Thank you.
Thank you. And Mr. McLean, please submit the proposed bond order to Ms. April Champion as soon as possible.
Yes,
All
Your
right,
Honor.
Mr. Young, thank you very much. Good luck, and please be sure to come back when summoned.
Yes, ma'am.
All right, next case in courtroom 2. Have we addressed everyone?
Yeah, everybody's completed.
Okay, thank you. I'm just going to go over the calendar. Courtroom 2, you're free to stay. But position 1 is been arraigned and further notice for trial. Position 1, Dennis Allen, is reset to March 10th, 2022 for a possible plea. Position 2 was a plea. Position 3, Harris Darrell, is reset to March 1st. Position 4 is a non-negotiated plea. Position 5 is a plea. Position 6 is reset to next Thursday, which is March 3rd, for a possible plea. Positions 7 and 8 were released, so Mr. Myers is further notice for trial. Position number 9, Mallory Reed, is reset to March 1st. Position 10 is going to, that's also March 1st. Position 10, Nick Smith, is, what's going on?
It's a waiver, Mr. Howard, filed a waiver.
All right. Position 10 is waived arraignment, so that's further notice for trial. Position 11 was arraigned and further notice for trial. Position 12, Mr. Terrell Swinger, is reset to March 17, competency calendar at 11 a.m. Position 13 was a plea. Position 14 is reset to the March 3rd competency calendar at 11 a.m. Position 15 and 16 were pleas. Position 17 is arraigned and further notice for trial. On the add-on calendar, Mr. Beasley, both positions were a plea. And that concludes with our SAP calendar. We can stop the recording